Hello, everybody, and welcome to our next landlord lockdown training. And I'm delighted that I managed to persuade Robert Brown to come back again and do another talk for us about procedures in the county courts. Robert is a barrister, but he's also a deputy district judge. So, as we were saying earlier, Robert, you sort of straddle both sides, don't you? Robert?
Yes, thank you, Tessa. Hello, everyone. Hello, yes, that's right. I seem to be spending my time at the moment split, some of it on the practitioner side doing these telephone and video hearings, and some of it on the other side of the bench sitting as the judge dealing with these telephone and video hearings. So I'm hoping I can give you some tips on how to deal with these.
So you know what you're talking about. Just before Robert starts, I just want to say briefly, can you just confirm that you can hear us? So if you could just type in the chat box, yes, I can hear you, or something like that, just to give Robert and I security of knowing that we can be heard. If you do have any questions, do put them in the chat box. Robert's got 10 tips that he's going to go through, so we may not have time to answer all of them, but we'll do the best we can. And if we can't answer them all, then we may possibly do what we did last time, Robert, which is that you perhaps do a little blog post for us where we can put them online. But yeah, it looks like people are hearing us, so yeah, thank you, absolutely, everybody. So over to you, Robert.
Good. Thank you, Tessa, and yeah, thank you everyone who said that you can hear. I'm glad to know that. So let's try and get through. We've got some slides here where, as Tessa said, I'm trying to go through 10 tips for you for these telephone and video hearings. And just really brief background. We've had in court telephone and video hearings for some time. But the norm prior to February, March last year in the COVID-19 pandemic was always in-person hearings, and telephone hearings were much more of a rarity. They were reserved for some case management type hearings, generally only where there were two parties. They were a bit difficult to manage where there were more than two parties. And almost invariably only where both parties had solicitors acting for them. We just didn't have telephone hearings where there were litigants in person, except in very unusual cases. Video hearings were theoretically possible, but I've got to say I've never in practice done a video hearing prior to the COVID-19 pandemic. But everything changed. And for a period of time, remote hearings became the default mode, and things are going to start to change back. But one thing that we appear to have discovered is that some form of remote hearings are going to remain with us for the foreseeable future. And I don't think that we will be going back exactly the way that we were. So even once everyone is vaccinated and we measures start to be released and reduced, I think that there will still be a significant proportion of hearings being conducted by telephone and video that weren't done prior to March last year. So what do you need to do? Well, normally you'd go to court and that's not going to happen. So you need to make sure that you're going to actually be involved in the hearing. You need to be on the phone or on the video link. There will be an order or sometimes multiple orders, and you will need to check it carefully to work out how are you going to be connected, and in particular, what does the court need? If it is a telephone hearing, prior to the pandemic, these were normally done through a conference call provider. And that would be set up with a service. There are a few of them that do it. And then they would dial in the court, the judge. During the pandemic, because that system really requires solicitors to be involved, it's a bit tricky to set up. Court started using a different thing, a service called BT Meet Me, where actually the court dials out. So importantly, you need to check, are they going to need a telephone number to contact you? If so, you've got to make sure that you provide it. If it's a video link, then the link will be sent out by email. So do they need an email address? Check. Sometimes the order will say both. Check what needs to be provided and when it needs to be provided and who it has to be sent to. There's normally an email address to send those details to. Make sure you do it in time, because if you don't do it in time, there is no guarantee whatsoever that it's going to have been printed out and put on the file, which is particularly important if it's a telephone hearing, because often the judge is dialing out. If they don't have your number, they can't contact you. And what I would say at this stage is there's a little bit of a need to think ahead about where you are going to be on the day and at the time of the hearing, and what your setup is going to be. And as we go through my next 9 tips, you'll see some of the points that you'll want to have thought about when you're deciding, where am I going to be, what number am I providing, what email address, those sorts of things. But that's the first thing. If the court doesn't know how to contact you, you're not going to be involved in this telephone or video hearing. That's no good for you.
Can I just chip in here very briefly?
I want to talk
Robert?
about...
Can I just chip in very briefly and say that this is being recorded, and it is, once after it's over, it will be uploaded to our YouTube channel, and I will also give a link to this presentation with that, so you will be able to download it from the YouTube channel later, just so people know that.
Thank you, Tessa. That's helpful. Actually, one of the tips, number 10, that I'm going to get to is about recordings of hearings as well, so that sort of ties in. And you will see when you download the presentation that at the end of this, I've put some what I hope are useful links to various other sources of information. So please do use those. Review hearings. I've actually done a separate webinar with Tessa about the system that's been put in place of things called review hearings and substantive hearings for possession claims. So I'm not going to get into the ins and outs of that, but I do want to just flag up this idea of a review hearing, which is not really a hearing in the traditional sense at all. What happens is that before you get to a substantive hearing at which the court will consider the case properly, there is a review date set, which is described in this document, the overall arrangements for possession proceedings, as an important new opportunity for the defendant to obtain free of charge duty scheme advice, and for the claimant and the defendant to reach agreement with the assistance of the duty advisor. There's a whole load of things that you need to do as a claimant landlord about putting a bundle together and things like that, which I'm not going to touch on. But what's meant to happen at the end of the hearing day is that there's 5 minutes set aside for the judge to just look at the documents without the attendance of the parties and see if everything is in order. And if everything is in order, the judge will then list it for a substantive hearing. It is possible during the day that there will have been a measure of agreement. Occasionally, that might be a consent order that would need to be approved by the court dealing with the possession claim. More likely, it might be directions as to how it's going to be dealt with going forward. If things haven't been done properly, and if the bundle hasn't been done, the judge may simply refuse to list the hearing. But one of the things that you've got to do in advance is give the court of a telephone number, normally, that you will be available on during the day to discuss the case with the defendant or the duty advisor. Now, you may get no call at all. This may not happen, but you need to make sure that you are available, because there remains the possibility, particularly if you have a sensible duty advisor, that you can either settle the case, probably not possible, but more likely agree some directions to the future management of the case and save yourself some time going forward. So the tip really for this is make sure that you've looked at the order setting up the review date, that you have made sure that you've confirmed to the court that you are available on that date and the telephone number. And you just simply do make yourself available so that if there is any possibility for narrowing the issues or making progress, you can seize that opportunity. Because otherwise, as I think you all know, possession cases are taking a long time to work their way through the system. That's that innovation about review hearings. What else do you need to do, though, for an actual hearing? Well, you need to get yourself properly set up. And think about it for telephone hearings particularly. You need to be somewhere quiet. A lot of these tips that I'm going to give you are the best practice that you aim for. But remember, courts and judges understand that everyone is working through difficult circumstances, and it's not always possible to have absolute peace and quiet. And for instance, particularly if you've got young children or animals, they are prone to make noise at the most inopportune times. Courts understand that, judges understand that, but still you need to be somewhere quiet because you need to be able to hear and the court on the other side need to be able to hear you. Now, I said before in tip 1, think ahead. So think ahead about where are you going to be? Is there a particular room that you're going to be that you can use, that you can dedicate to this? And what number are you going to be available on? And I've said, my experience, a landline is normally best because landline, the signal tends to be a bit stronger than it does on a mobile. And also on landline, subject to how you set up, battery doesn't tend to run out as it might do on a mobile phone. So, but of course you have to fit this around your own circumstances, but landline normally best. You might be sat there waiting for some time. I would suggest you want to make sure you've got a drink of water there. You will need to make some notes as you would in court. Get paper, get pen, get all of these things sorted, and try to make sure you've got all of the court documents available because you don't know what issues might come up. And it's no use saying, oh, I've got that, but it's upstairs, it's in another room, I've got to go rummaging through the, my files, whatever. There isn't necessarily going to be time to do that. And importantly, you want to be ready to answer the phone as soon as the court calls. That there is not enough time in the court day to deal with all hearings anyway. If court is having to ring you 3, 4, 5, 6 times, which some judges will if they don't get an answer. Some may only ring once or twice. If there's no answer, that's it, they move on. It's taking up valuable time that you want to use for your case to be dealt with. So just but thinking ahead, getting yourself set up, and then remembering that just because your case is listed for, say, 12:30 doesn't mean you're getting a call at 12:30. You could actually get a call from a little bit before that until, I think the orders normally say you need to be available for about half an hour after the time. It may even be later than that. And if you're still available, the court will be able to deal with it. So it's not easy, but I think one of the things Tessa and I were discussing before this started, it's probably better and more comfortable waiting arrangements than you would find if you got to go to court and just sit in the waiting room hanging around, not knowing what was going on. You need to think about how you're going to be connected and the equipment that you're going to be using. And I've said for telephone hearings, my normal suggestion is landline rather than mobile phone if you can do that. For video hearings, think about what you're going to be using. I've suggested that a computer is normally better than a tablet or phone. It's slightly easier to use. I find that might be an indication of my age. But you do tend to find actually you get a better network connection with a computer than you do a tablet or phone. You think about it, that's not surprising. They're going to have bigger network cards built in, better signals. But use the best thing that you can, obviously. Do check your download and importantly your upload speeds, because remember you're having to send a video signal over the internet to the other side. It's wonderful having a fast download speed. You'll see what everyone else is doing, but unless you can send things upstream at a reasonable speed, you're going to be blocky and blurry for everyone else. There's been lots of talk amongst lawyers in the last year about two-screen setups and all of these sorts of things. Can I tell you, the best investment that I've made for video hearings in the last year is I bought myself a 20-meter Ethernet cable to plug straight in from the back of the computer into the router a couple of rooms away. And that then means, touch wood, I have a rock solid connection rather than having to rely on Wi-Fi. I also, just again, in terms of thinking ahead, I don't know if any of you ever find sometimes that your router just needs to be restarted, needs a good kicking sometimes just to get it working with the internet signal. And I think that sometimes depends on different broadband providers. But if you've got that sort of problem, or if you have problems with the Wi-Fi, just think ahead and possibly turn everything off and on, which is what it normally needs, the morning before the hearing, just so that you know that it's all working then, rather than it's going to drop out during the hearing. Software. Video hearings are done a number of different ways through different software platforms. The court started off using something called Skype for Business, which was not Skype that many of you will be familiar with, but some different and in many ways inferior alternative. But they have very quickly actually rolled out a thing called the cloud video platform, sometimes abbreviated to CVP, and you may see this on orders. And the cloud video platform, CVP, works pretty well actually for a lot of cases. It is accessed through a web browser. Normally, you're not going to be worried about an app or program that you need to, a specific program that you need to have installed, but you do need a web browser. The order will set some of this out actually. Chrome is recommended. I should say I have quite successfully used Safari as well, and others will also work, but Chrome is the one that's recommended. And there are a few links available, and you'll see one on that slide there, and there's some more at the slides towards the end about things that you can look at as to the steps that you will take when joining the hearing. What you'll need to have is there should be an email sent out with a link that you will need to click on. Some courts will also give you a PIN, a number that you're going to need to add in. Some don't. That practice just varies on that, but do check the email carefully to see what you're going to need to access it. And bear in mind that the onus then is on you. You're going to need to log into that service and be joined in, and make sure that you have authorized in your security settings and so on, microphone and camera, so that the court can hear you and can see you. And there will be a little text box for you to put your name in, and do just fill that in. That helps tremendously of everyone knowing who everyone is. You'll see the final bullet point there. Microsoft Teams and Skype for Business. There's a couple of other services that some courts are using. Tribunals, particularly at the moment, seem to be using Teams rather than CVP, but things are changing. These services all work in very similar but slightly different ways. You just need to know ahead of time which one you're using. See if it's all possible, if you can do a sort of trial run of it, and make sure that it's going to work with your various technology, with your device, with your connection, and so on. And although I've put the link on this slide just for the information on CVP hearings, in the link sort of got at the end of the slides, there's a similar bit of information about Teams and a similar one for Skype for Business as well. So you can check that ahead of time. Again, in terms of your setup, how are you going to do this? How are you going to deal with the hearing? You will normally, particularly if you're the claimant, have been required to prepare an e-bundle, an electronic bundle. There's a lot of advice out there about how to do that. There are some videos that have been put together. There are various web pages and guides that people have put out, which I've not put in this, but do look out for those if you're going to need to do it. But in any event, someone should have done an e-bundle. You need to think how you're going to look at that. Lots of lawyers who are set up for many remote hearings, as I say, have got a second screen. That's probably going to be overkill for many of you. But think about how you're going to do it, because if you're using the computer or your device as the sort of access point for the video hearing, it's not always all that easy to have on the same screen the bundle that you need to use. You might want to do it on a second device. I'm not so fancy as to have a second screen, but I have got a laptop that I then put to the side, which I have with just the bundle on it. Because I am always worried about technological failure and things falling over and breaking down, I make sure for big hearings, long cases, trials and things, that I also have a hard copy to the other side, which I tend at the moment not to do a hard copy of everything, but just the key documents that I think I'm going to need to refer to frequently. And then you've got the e-bundle for everything else should it come to it. And that's, from my experience, a good tip to pass on, that it is worth having, depending on how technologically savvy you are and how comfortable you feel using e-bundles and so on, but I find it useful to have a hard copy of key documents just to one side. So I have my laptop to my right side, my right hand side, which I can use for the e-bundle, and to the left hand side I have the hard copy bundle that I use for the key documents as well. Now, lots of hearings you'll be dealing with will be relatively short hearings. Substantive possession hearings are only going to be 15, 20 minutes normally. And it may be that you're just dealing with those yourself, but you may be dealing with small claims hearings. You may even be dealing with trials where there are other parties involved. You might have a solicitor, you might have a barrister, you may have other people that you're working with. You're not going to be in the same location. If you're in court and there were points that arose, you scribble it down, normally on a post-it or other brand of note, and you pass them back and forth. You can't do that. So how are you going to communicate between the parties? You will want some kind of messaging system. I mean, you can use email. You might want to use text messages or iMessages, or WhatsApp or similar sorts of services. Just make sure that if you've got a little circle of people that are involved, you, your solicitor, your barrister, whomever it might be, that you're all on the same page as to what it is that you're using, that you have turned off all the whizzy announcement noises. The last thing you want is in the middle of you saying something to the court, there to be a sort of alarm noise going off from your computer or your phone because a message is coming in. You don't want it being too intrusive. And one really important thing you've got to remember, if you set up a message group for exchanging communications during the hearing, and this is a hearing where people are giving evidence and being cross-examined, when you are giving evidence, you're not supposed to be communicating with anyone else. You're just answering the questions. So do just make sure that you have, if you're doing this sort of thing, that you've got groups set up that exclude people, exclude witnesses when they are giving evidence. You'll also just want to think about the security and privacy aspects of this. I know this has been said a lot in relation to WhatsApp and how secure and how private it is, and just make sure that you just have a think about what it is that you're sending back and forth, that you've got it properly secured. Think about whether you need to have it encrypted or not. Now, if you are doing sorts of hearings, long hearings where this sort of thing is necessary, then hopefully there will be some legal professional engaged who can deal with some of these aspects for you. But these are important things to consider for those sorts of hearings. What else have you got during the hearing? Well, this is often missed actually, because it's so easy, particularly with the video hearings, but also the telephone hearings, to conduct your own recording. You cannot do that. And if you do a telephone hearing, you will probably find that at the start of it, the judge will give you a little spiel, effectively from a script, that you cannot record or indeed broadcast or publish any part of the hearing, and that it is a criminal offence to do so. And it may also be a contempt of court. And it's worth mentioning this because it gets forgotten even by those who really should know much better. The BBC recently broadcast in a news feature a clip about 6 seconds long of a hearing taking place in a planning matter in the High Court. There's no sound, they just use a bit of the video footage effectively as a sort of background feature. That's unlawful. They weren't allowed to do it. They tendered a very sincere apology, but were still given a fine that ran into 5 figures. I think it was somewhere between £20,000 and £30,000 for having broadcast this. It's something the courts really do frown upon. So no recording, no broadcasting. Please don't get yourself in trouble over that. As I say, the hearings should be being recorded by the court itself. We'll come back on to that. You may find that there are several parties involved, and even if there aren't several parties, there can be a tremendous amount of background noise even when there's just 2 people involved. If you're searching the e-bundle, you might be typing keys on your keyboard. If you're turning the papers, that can make quite a rustling noise. So do try to mute yourself when not speaking. if you go through BT Meet Me, there is a keypad combination that you can press on the telephone to mute yourself and unmute yourself. If you're doing it through one of the video hearing services, there will be a little icon that you can click on the screen, a little microphone icon, it looks like, to mute and unmute yourself. Please do just do that. It makes it much easier for the court. It makes it much easier for everyone to manage the proceedings, and it reduces the level of background noise. Actually, a similar point about telephones. It's quite tempting to put your telephone on speaker mode. You will just need to watch out for that. That can get quite unmanageable if lots of people are doing it, because depending on the phone, you then get a lot of feedback and a lot of echo. So the very good, very modern smartphones are actually quite good at dealing with that so that you don't get too much feedback and echo, but it can quite quickly get unmanageable. So you may, I'm afraid, just need to hold it to your ear, unless you've got some sort of headset or something. But the most important thing that I've got to say, and this is something that does, I think, to seem to be getting missed sometimes, and it's easy to see how you're in your home, it's quite different to the formality of going to court. It is still a formal court hearing. You need to recognise it as such. There have been tales of people smoking, vaping during hearings because they're in their home. It doesn't give the right impression. It doesn't show that you're properly recognising the formality of the proceedings. And one tip that really goes with that is dress as if you were in court. And actually, my top tip on that one really is, even for a telephone hearing, and I say that's more a do as I say than do as I do, because I don't always do that, but it's probably a good idea to do that, because I've heard of people who 5 minutes before a telephone hearing have been surprised to find that actually it's now been shifted to a video hearing, and they have to scramble around to make themselves look presentable for a video hearing. What else? Witnesses. If you are doing, and again, for possession hearings, when they're in the possession list, even as substantive hearings, this probably isn't going to be an issue. But if you are doing something where it's a contested small claims or actually listed for trial, there are going to be witnesses giving evidence from a different location. If you are one of the parties, you need to make sure everything I've just discussed that you will have got set up for yourself, you need to make sure that your witnesses have got it all set up. Because if they don't, it's not going to be possible to proceed with your case. And in particular, you've got to make sure that they've got the documents. So that means their witness statement, but it actually means the bundle, not just their witness statement, because the other side might want to cross-examine them by reference to documents in the bundle, and it's no good if they don't have the bundle. So double check they've got it, and then check again. I really mean that, because hearings are happening where the hearing starts, someone gives evidence, you then move on to the next witness, and it turns out they don't have even their witness statement or the bundle. And it can be difficult then, because sometimes it's possible to get things set up so that you can then send a copy of the bundle and move on. But actually, what often happens is it just means that the hearing has to go part heard. It's adjourned to another day. More time, more money. And finally, I said about recordings. These hearings should be recorded by the court service through whatever service. Normally, if hearings are in court, actually people turning up, there's a computer system that records it and it's burned to a CD or DVD, and then those just get archived somewhere and you can request a transcript. If it's done through one of these services, particularly BT Meet Me, as I understand it, the recordings aren't actually kept for very long. They are deleted automatically after a set period of time. I think it's about 4 weeks, but I don't know that for definite. If you're going to need to appeal, you're going to need to get a transcript. And normally you'd put in your notice of appeal, and then you'd make your request for a transcript from the court, and it would come through. And there's no desperate rush about doing that. If it's a telephone hearing or a video hearing, because these are not necessarily being kept for as long, you've got to make sure you put the request in for transcript as soon as possible. If it's not done, you're going to have real difficulty in demonstrating that something was said or not said during the hearing. So that's often missed. And that is my final and 10th tip as to the different ways to approach video and telephone hearings compared to in-person hearings. I'm not going to go through the other 3 slides, but on those I've put a few links about various bits of information sources and a few videos that HMCTS have put together about telephone and video hearings, which are quite useful to watch and just see how they might be conducted.
Okay, that's fantastic, Robert. Thank you so much. I'm sure anybody who is faced with a telephone or video hearing are going to find that really, really useful. You'll be pleased to hear that we haven't had any questions. So you've obviously covered all the points.
Excellent.
So and
good.
We're on.
Well, I hope so.
So we're on the hour. So that's brilliant timekeeping. So I think probably it remains for me to say thank you very much, and we will close down. As I said, this is being recorded. It will be put up on the Landlord Law YouTube channel, and I will try and send a link out to everybody so you know where to pick it up. So thank you, Robert, and goodbye. Thank you, everyone, for attending.
Thank you, Tessa, for setting it up.
Okay, then. Right.
Thank you. Goodbye.
Bye-bye, everyone.